the 19th interested party.
Estimator that matter my name is Arua. Here together with this man.
The 22nd interested party.
Wait, please, the court. Dr. Kamodo for the 22nd interested party.
Also, for the 32nd interested party.
Estimator that matter I hold for that particular interested party hold due for the Zambia.
We left anyone out? Thank you. This matter is for judgment this afternoon. We have two judgments that will be reading after this session. The consolidated petition is threefold. Firstly, it challenges both the constitutionality and process of establishing the office of the Chief Administrative Secretary, hereafter the office of the CAS or CASs. A related argument is that the office of CAS is a state office which can only be lawfully established through an act of Parliament. Secondly, the petitioners are aggrieved by His Excellency the President the past exported unilaterally creating additional 27 positions of CASs beyond the 23 that were created on the recommendation of the Public Service Commission, thereafter the PSC, or being exported. Thirdly, it is considered that the additional offices will impose an additional financial burden to the public, contrary to constitutional and statutory imperative included in the public resources. The first petitioner claims for various regulations and orders, including nullification of the appointment of all the 50 CASs, the second to 51st interested parties, and declarations that Section 26, Section 2 of the Salaries and Remuneration Commission Act, and the Salaries and Remuneration Commission, Remuneration and Benefits of State and Public Officers regulations are unconstitutional. The second and third petitioners, on the other hand, seek, among other prayers, a declaration that the President is bound by the recommendations of the Public Service Commission on creation of an office in the public service under Article 132, Sub-Article 4A of the Constitution, and a declaration that the recruitment process for the interest of parties was in violation of the Constitution as well as the Public Service Act. They say that the appointments of the 50 CASs are enforced. They also contend that the PSC abdicated its mandate under Article 2.4 of the Constitution by establishing a public office contrary to Articles 10 and 232, and the process of vetting and approval of the interested parties for the National Assembly would be in breach of Articles 2, Sub-Article 2, 4, 10, 94, 95, 232, and 259 of the Constitution. The fourth petitioner seeks, in turn, for a declaration that the appointment of the CASs is a waste of public funds and resources. Clearly, that in the face of the high unemployment levels and economic recession facing Kenyans, the appointments of Article 10 of the Constitution with specific regard to prudent use of public funds and resources and sustainable development. A short history of the exhibition is like on 5th of May 2023. On 23rd of May 2023, the Honorable Chief Justice directed that the petition be heard by this bench. It is imperative to note that on 28th of April 2023, we had read at directions for the disposal of the earlier petitions and set a hearing date. At the hearing on the 25th of May 2023, the bench consolidated the new petition with the other two and issued fresh directions. The read petition remained E080 of 2023. The consolidated petition is strenuously opposed by all the respondents and all the interested parties through some grounds of opposition, various replying affidavits, and notices of preliminary objections that we shall particularize later. We should point out that the President, first respondent, did not file any response to the petitions. However, the Attorney General, second respondent, raised a preliminary objection that the President was wrongly sued and should be removed from these proceedings. The PSC, that is the fifth respondent, on the other hand, did not file a reply but sought to benefit from the affidavit of Felix Koske filed on behalf of the second respondent. We shall deal with the propriety of that matter later. The key objections by the respondents and interested parties are as follows. Firstly, that the issues raised fall squarely within the jurisdiction of the Employment and Labor Relations Court. They thus contend that the High Court lacks jurisdiction to determine the dispute. Secondly, that the issues are res judicata in view of two earlier decisions of the Superior Courts read by Murima J, Inokia Omtatal and another versus PSC and 73 others, 2021, and by Baru J in LSK and two others versus Attorney General and others, 2022. Thirdly, it is contended that the petitions are premature and non-justiciable. Fourthly, that the petitions are poorly drafted and imprecise. Fifthly, that the respondents have not breached the Constitution or any statute. And lastly, that the President enjoys immunity from suit and is thus wrongly enjoined into the suit. On 23rd of March 2023, the Sigo Judge, Ongudi J, granted a conservatory order barring the interested parties from assuming or continuing to act as the CASs. Those orders were confirmed by the full bench in a considered ruling dated the 28th of April 2023. The Attorney General, second respondent, Mr. Dennis Itubi, and Engineer Nicholas Gubo, the 19th and 22nd interested parties respectively, had also lodged preliminary objections to the jurisdiction of the court and asserting that the suit is res judicata. Following directions by the bench on 28 April 2023, the parties agreed that those matters form part of the reply to the consolidated petition and be determined in our final judgment. And be determined in our final judgment. also summarized the various pleadings and affidavits and materials placed before the court, and we have also summarized your very comprehensive submissions, and we shall not be reading them in detail.
The issues for determination. From the pleadings, evidence, and submissions, the following are the main 7 issues arising for our determination. 1. Whether the High Court has jurisdiction. 2. Are any of the issues res judicata? 3. Was there adequate public participation in the creation of the office of CAS and in the appointment of the CASs? 4. Did the President and the PSC have the power to create the present office of CAS in the manner in which it was created? 5. What are the financial implications of the creation of the office of CAS, and is it a waste of public funds contrary to Article 10 of the Constitution? 6. Was the President improperly enjoined as a party to the consolidated petition? 7. Who should pay the costs? We have also found that the following supplementary issues call for our determination. 1. What is the constitutionality of Section 26(2) of the SRC Act and the regulations thereunder? 2. Was the first interested party improperly joined as a party to the consolidated petition? 3. Was the consolidated petition drawn with sufficient precision? And 4. Should the court consider matters that were not properly pleaded? On the first issue, does the High Court have jurisdiction? We have considered the written submissions of counsel, as summarized above, together with the numerous authorities cited in support of the said preliminary objections, including migepe versus Clerk of Kiambu Assembly, and several others. I will not recite them all. Having carefully considered the above authorities and the submissions of counsel, in particular the argument that the ELRC has unique competencies in the areas of employment and labor relations law, and that this court ought to defer to it on that basis, respectfully we find otherwise. We are guided by the decision of the Supreme Court of Kenya in Samuel Kamau Macharia, Supra, where the Supreme Court held as follows: a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The jurisdiction of this court flows from the Constitution of Kenya. Article 165(3)(d) of the Constitution reads as follows, and I will not read out the entire clause because I know we're all familiar with it, but I will move forward and say that based on the law as set out above, and looking at the various issues raised in the consolidated petition, we are of the view that our mandate has been properly invoked. In particular, the consolidated petition raises numerous and weighty constitutional issues that go beyond employer and employee issues. The primary or core issues before this court are in fact constitutional in nature and call upon this court to interpret the Constitution as a whole in order to reach its conclusions in relation to the issues and relief sought. This exercise falls squarely within the confines of Article 165(3)(d) as set out above, and we find that this court is accordingly properly seized of jurisdiction. Based on our reasons as set out above, we find that the preliminary objections dated 21st and 31st of March 2023 are without merit and the same are dismissed. The next issue. Are any of the issues raised in the consolidated petition res judicata? The first to the fourth petitioners sought the following consolidated reliefs in the consolidated petition. I will not read them all out, but our decision has summarized them all. I will go straight to the next part after that. Subject matter, namely in Okia Umtata and another versus PSC and 73 others, and LSK versus the PSC and others in the Employment and Labor Relations Court. A reading of the above decisions by the High Court and the ELRC reveals that each court heard and determined the matters conclusively and reached various conclusions in relation to numerous issues that are presently before this court. Accordingly, several of the petitioners, respondents, and interested parties rightly submitted that those issues determined by the said courts are accordingly res judicata. We are of the view that res judicata applies to a number of issues in the present consolidated petition which have been litigated at length and determined, albeit involving different parties to the present consolidated petition. We do, however, note that LSK 74 of 2022 and in the Employment Labor Relations Court, and was also an interested party in the Okia decision. Considering the above, this court is of the view that several of the issues have been litigated, even if some of the parties to the present petition are different. Moreover, those issues ought to be res judicata on the basis that the issues in the present matter are more akin to issues in rem rather than issues in personam, because they affect a state of affairs and the society at large within the Republic rather than purely private interests. We do not think that a court ought to relitigate the same issues over and over each time a new party files a petition relating to the same subject matter. To do so would lead to an absurd outcome and embarrass the court with contradicting decisions. Having read the above said decision, this court notes that already the High Court and ELRC reached different conclusions in respect of a number of issues that were common to the two petitions. In order to avoid creating a third view in relation to the same issues, this court will treat some of those issues determined in the above cases as res judicata for the reason that they have been conclusively dealt with by a court of equal jurisdiction. Moreover, we emphasize that the judgment in Okia Supra is presently pending appeal in the Court of Appeal. That said, we note that the original office of CAS, established on 24th January 2018, and which was the subject matter in Okia, was abolished by the PSC on 21st September 2022. That was the office that was subject of the stay order in the Court of Appeal. One of the issues now raised in the consolidated petition is whether the new office, established by the Gazette Notice 12th October 2022, is constitutional, and whether the complement of office holders appointed on the 16th March is lawful. Based on the above reading, we take the view that this court ought not pronounce itself on issues that are presently pending appeal before a higher court. We find that the following issues relating to relief sought in paragraphs B, C, and O, stated and listed above at para 189, are res judicata. We refer to the following paragraphs in the Okia decision in respect of the same. Issue B, namely, the office of CAS that the first respondent created are state offices, which can only be lawfully established and designated as state offices by national legislation, was dealt with at para 154 in the following terms. Having said so, it is without any doubt that the position of CAS in every ministry was finally created. These are senior government positions in the public service. The holders of such positions are state officers. There is no doubt that such positions have a significant impact on the National Compensation Bill. As said, the input of the SRC was mandatory. Further to the above, the court partly addressed the question of whether or not legislation is required to underpin the appointment process. The learned judge was particularly concerned with legislation for the purpose of approval of the candidate by the National Assembly and to enable public participation, as opposed to legislation intended to replace the appointment process. Quoting with approval the decision of our brother Justice Rika, the court referred to the appointment process relating to the managing director of the KPA and stated as follows. I will not read the entire quotation. I'll move forward and say, as regards issue C, relating to the role of the National Assembly in the appointment process, the court found as follows at paragraph 235. It is therefore the finding of this court that the persons who are appropriately appointed to the position of PS and CAS are only those who, 1, apply for such positions once the PSC advertised vacancies, 2, are shortlisted by the PSC, 3, are interviewed by the PSC, 4, are recommended for nomination for appointment by the PSC, 5, are nominated by the President for such positions, 6 are approved by the National Assembly, and 7 are appointed into the office of PS and CAS by the President. As regards issue K, in relation to whether or not His Excellency the President is bound by the recommendations of the Public Service Commission in the creation of an office in the public service under Article 132(4)(a) of the Constitution, at paragraphs 235 and 142, the Court stated as follows. Again, I will not read out the quotation. We are therefore of the opinion that the said above stated issues ought to be excluded from our determination on the basis that the same are res judicata.
I'll now invite my learned sister, the Honorable Justice Hedwig Ongudi, to deal with the next issue.
So the next issue is as follows. Was there adequate public participation in the creation of the office of CAS in respect of the additional 27 posts? One of the key contentions in this petition is that the creation of the office of the CAS did not adhere to the principle of public participation for the 27 additional posts. We've referred to the Supreme Court case in British American Tobacco Kenya PLC versus CS for the Ministry of Health and 2 others. The sequence of events that led up to the establishment of the office of the CAS are captured in the affidavit of Simon K. Rotich, the PS's CEO's officer's response in the ELRC petition number E174 of 2022 and relied upon by the LSK in the instant petition, and the affidavit of Felix Koskei, the head of public service. The PSC on 19th of September 2022 received a letter from the then head of public service, Joseph Kinyua, informing it of the President's proposal on the establishment of the office of the CAS in the public service. The correspondence set out the history of the office and the justification for its establishment. Considering this, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry except in the Ministry of Interior and Coordination of National Government, that would have 2 positions in light of the scope and significance of the portfolio mandate. The letter also listed the job description for the CAS and relevant qualifications. The PSC, at its weekly meeting on 21st of September 2022, discussed the proposal, where it was observed that the office had been established in January 2018. However, the process of establishing the office was declared unconstitutional in the Okia case for lack of compliance with Articles 10, 47, 132, 201, 232 and 234 of the Constitution. In view of this pronouncement, the PSC resolved to abolish the CAS office established on 24th of January 2018, comply with the dictates of the judgment in light of the President's request, and conduct public participation. In this regard, the PSC via a press advertisement on its website and the local dailies dated 21st of September 2022 invited members of the public to submit their views on the proposed establishment of the said position, and to do so by 6th of October 2022. The PSC, in its response dated 11th of October 2022 to the President's letter dated 19th September 2022 through its chairperson, Anthony Mushiri, divulged that following the public participation exercise, the PSC received 498 a bloated wage bill, the resultant economic burden to taxpayers, and that the role was a duplication of the CS and PS. The PSC considered and analyzed the responses, and in the end, noting that the conditions of Section 27 of the PSC Act and public participation had been complied with, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October 2022 as communicated by Joseph Kinywa, the then head of public service, to the PSC chairperson, Mr. Mushiri. It is revealed further through the affidavit of Felix Koskei, the head of public service, in a letter dated 24th of April, that on 23rd of February 2023, the President wrote to PSC seeking a review of the complement of CSSs within the public service to vary from one in each ministry to one in every state department. On the same day, PSC CEO Simon Rotich wrote to the PS, Chris Kipto, seeking concurrence on the availability of funds to meet the resultant expenditure of the additional 27 posts. The PSC, in response to the President's letter, consented to this variation in its letter dated 27th of February 2023. In the letter, PSC noted that the consent was based on workload attendant to the role of CAS and National Treasury's confirmation of funds. Following this communication, the President increased the complement of the office with additional posts. The PSC was then asked by the President to recommend persons to be appointed, which it did. Moreover, in response to a letter dated 18th of October 2022 and two letters dated 10th of March 2023 by the PSC, the SRC wrote a letter dated 14th of March to the PSC advising it on the job evaluation, grading and remuneration and benefit structure for the position of CAS in the public service. Soon after, the 2nd to 51st interested parties were nominated on 16th of March and appointed by the President on 23rd of March 2023. Two things are clear from the foregoing account. First, the initial proposed number for the office was 23. It is discernible that the process of public participation that was undertaken by the PSC was with reference to the letter from the President to PSC dated 19th of September 2022, which only requested for 23 posts. On the flip side, the sequence and procedure that led to the establishment of the 27 additional posts did not adhere to the constitutional principle under Articles 10 and 232 of the Constitution and conditions set under Section 27 of the PSC Act. This process, in our opinion, did not satisfy the guiding principles set out by the Supreme Court in the BAT case. We say so because, as a guiding principle, public participation must be real and cover all forms of governance. It is noted that the public submitted comments in the public participation exercise based on creation of the CS office in each ministry, not each state department, as indicated in the President's letter dated 23rd of February 2023. It was incumbent upon the PSC to prove that the public participation exercise covered all the additional 27 nominees. This was not done in accordance with the BAT case, and in essence, based on the record before us, it is evident that PSC failed in its mandate. The undeniable conclusion is that the process of establishing the extra 27 posts was unconstitutional.
I'll go straight to the next issue. Did the President and the PSC have the power to create the current office of CAS in the manner in which it was created? The consolidated petition requires us to interpret a number of articles in the Constitution. We are well guided by Article 259, which provides as follows, and I shall not read it. The principles governing interpretation of the Constitution are well settled. The Supreme Court, in Communication Commission of Kenya, and 5 others versus Loyal Media Services and 5 others, stated that the Constitution should be interpreted in a holistic manner, within its context and in its spirit. In Lena Concheral and others versus Chief Justice of the Supreme Court of Kenya and others, the court restated the principle that the Constitution should be given a purposive interpretation where all provisions are read as a whole, with each provision sustaining the other. The following passage appears in Gatirao Peter Munya versus Dixon Mwenda Kitheji and 2 others in Supreme Court Petition number 26 of 2014. I shall not read it. This principle was restated by the Court of Appeal in Attorney General versus Law Society of Kenya and 4 others, 2018, and a number of other decisions that we have considered. I shall not read them out. The Supreme Court in Samuel Kamau Macharia and another versus Kenya Commercial Bank Limited and 2 others held as follows, and I quote, "At the outset, it is important to note that a constitution is not necessarily subject to the same principles against retroactivity as ordinary legislation. A constitution looks forward and backward, vertically and horizontally, as it seeks to re-engineer the social order in quest of its legitimate object of rendering political goods." I shall not read the rest of that paragraph. Applying those principles to the matter at hand, we find further as follows. The history of the office of CAS is fairly recent, having been first established on the 24th of January 2018. However, on 20th April 2021, the High Court in Okiya Lomtata Okoitil and another, Supra, declared the office to be unconstitutional. That decision was stayed by the Court of Appeal in Public Service Commission and 72 others versus Okiya Lomtata and 4 others. The main appeal is still pending. In granting the stay, the learned judges of the Court of Appeal found, and I quote, that public interest underpinning the substratum of the intended appeal would demand that we affirm the interim orders in terms of prayers 2 and 3 of the application issued on the 15th of June 2021, and which we hereby do. Cost of the application to abide the outcome of the intended appeal, unquote. To fully appreciate the terms of the order of stay, we looked at the wording of prayers 2 and 3 of the appellant's notice of motion dated the 29th of April 2021, brought under Rules 5, 2B, and 47 of the Court of Appeal Rules. They were couched in the following terms. 1, that pending hearing and determination of this application, there be a stay of the judgment and order of the High Court, Murima J, made on 20th of April 2021. For the avoidance of doubt, pending the hearing and determination of this application, the offices and the individuals currently holding the offices of Chief Administrative Secretary, Cabinet Secretary, and Principal Secretary shall not in any manner be affected by the judgment on order, and the Honorable Attorney General shall not be required to file an affidavit in the matter within 30 days of the judgment or at any time. And 2, pending the hearing and determination of this application, the High Court shall not take any steps in enforcing the judgment or order made on 20th April 2021 in High Court Constitutional Petition number 33 of 2018 as consolidated with High Court Constitutional Petition number 42 of 2018. For the avoidance of doubt, pending the hearing and determination of this application, there be a stay of proceedings before the High Court, and an order do issue that the Honorable Deputy Registrar shall not schedule the matter for mention, and the High Court shall not mention the matter to issue any further orders, unquote. It is our considered opinion that the above stay did not reverse the findings or declarations or orders of Murima J, that the office of CAS as then constituted was unconstitutional. The learned judges only granted a stay of execution in the terms of prayers 2 and 3 that we have set out above. Furthermore, the main appeal is pending. We have then closely studied the decision of the Employment and Labor Relations Court in Law Society of Kenya versus the Public Service Commission and the Honorable Attorney General, Petition 174 of 2022. The respondents have relied on that decision for their proposition that the learned judge, Baru J, filed the advertisement calling for public comment and the creation of the office to be lawful. We fully appreciate that we cannot review or stand on appeal over a decision of a court of concurrent jurisdiction. However, we are also alive to the fact that we are not bound by the decisions of Murima J and Baru J above. The suit before the ELRC was challenging the validity of the advertisement by the PSC dated the 21st of September 2022, inviting public views on the establishment of a new office for CAS. The petition was dismissed. For the avoidance of doubt, the prayers as set out in the face of the judgment were: A declaration that the advert of the first respondent dated 21st September 2022 is illegal and irregular for violation of Section 27 of the Public Service Commission Act 2017, insofar as it fails to include fundamental details under the said Section 27, subsection 1, to enable the public to make meaningful and informed contributions towards the establishment of the office of CAS. B, a declaration that the advert of the first respondent dated 21st September 2022 is illegal, irregular, and unconstitutional for violating Article 201, Sub-Article D of the Constitution, as it seeks to establish an office in the public service with duplicity of roles as that of principal secretary, contrary to the principles of public finance. C, an order that the said advert of 21st September 2022 be declared a nullity, as it fails to provide crucial information that enables the public to make informed contributions in the establishment of the office of CAS. D, an order that the first respondent be required to provide information provided for under Section 27, subsection 1 of the PSC Act in any public participation before the establishment of public office. And lastly, E, each party to bear its own cost. The learned judge of the ELRC interpreted the stay by the Court of Appeal in Public Service Commission in 72 laws. The first respondent, PSC, took into account that after the Court of Appeal stayed the High Court judgment addressed above, parties then reverted to the position subsisting prior to the judgment, unquote. The learned judge then went on to find that all the legal parameters for establishment of the office were met. It is imperative to note that the Law Society of Kenya did not appeal the dismissal of its petition by the Employment and Labor Relations Court. We are cognizant that the courts established by Article 162 of the Constitution have the same status as the High Court. As we have stated earlier, whereas we have no power to review the decision of a judge of concurrent jurisdiction, we are equally not bound by it. Having set out the approach taken by Baru J above, we are of a different view. especially because of the findings by Murima J that the office of CAS is unconstitutional, have not been set aside and are pending appeal. For instance, Murima J found that the procedure in Section 47 of the PSC Act recommending appointment of let me read that again. For instance, Murima J found that the procedure in Section 47 of the PSC Act recommending appointment of permanent secretaries applied mutatis mutandis to CASs. He held as follows, and I will not read the paragraph. Following the above judgment, and on 21st September 2022, the PSC resolved to abolish the office of CAS altogether and to commence the process of creating a new one. The record shows that PSC was prompted by a proposal from His Excellency the President to establish the office in accordance with Article 132, 4A of the Constitution. To be precise, on 19th September 2022, the head of state and government, through the head of public service, wrote to PSC, and I quote, to establish the office of Chief Administrative Secretary within the ranks of the public service, unquote. PSC concurred with the proposal on the 11th of October 2022. On the same day, the head of public service acknowledged receipt of the letter and requested the PSC to advertise for 23 positions of CASs. A copy of that letter is attached to the affidavit of the first petitioner, marked EKM 001. We have set out in another part of this judgment the timelines up to the point the new CASs took their oath of office. According to the affidavit of Henry Rotich, sworn on the 19th of October 2022, the PSC resolved, and I quote, to comply, unquote, as much as it could with the findings of Murima J in the Okia case, notwithstanding the order of stay and the pending appeal. The PSC placed an advertisement on 22nd September 2022 in the local dailies, calling for comments from the public on the proposal to establish the office. Those comments were to be received on or before the 6th of October 2022. As we have mentioned earlier, that was the advertisement that was challenged by the Law Society of Kenya in the Employment and Labor Relations Court. We have no doubt that Article 132, Sub-Article 4A of the Constitution expressly grants His Excellency the President power to create an office in the public service. But in doing so, he and the PSC are bound to follow the requirements of the Constitution. We agree with Murima J in the Okia case, Supra, where he stated, and I have quoted, but the following lines are important: the procedure for establishing an office in public service has its basis in the Constitution and law. This has its basis in the Constitution and law. Article 132, 4A of the Constitution provides that the President may perform any other executive function provided for in this Constitution, all in national legislation, and, except as otherwise provided for in this Constitution, may establish an office in the public service in accordance with the recommendation of the Public Service Commission. In undertaking such duties, the President and the PSC must comply with the Constitution. That is the calling in Articles 3 and 10 of the Constitution, unquote. Given the nature of the present dispute, it was imperative for the Public Service Commission to file a replying affidavit clarifying the role it played in evaluating the request by His Excellency the President and seeking any advice from necessary bodies such as the SRC and in rendering its final advice to the President. Being a constitutional commission, it was to be guided in its decisions by the principles outlined in Article 10, for its actions. Granted that background, the failure by PSC to file a replying affidavit answering the specific allegations leveled against it, and to choose instead to rely on the defense by other parties or their depositions was a serious omission. It in part remains that some allegations by the petitioners against the PSC were not sufficiently rebutted. See General Irene Wagari-Gashero and 6 others, 2017. We are, however, alive to the fact that the PSC is not the sole respondent here, and that the affidavit of Mr. Felix Koske, Chief of Staff and Head of Public Service in the Office of the President, sworn on the 24th of April 2023, and filed by the Attorney General, second respondent, is useful to the case of the Public Service Commission. But it certainly cannot provide a full answer to all the allegations made against it by the 4 petitioners. The PSC, in its submissions before us, sought to rely on the affidavit of Simon Rotich, sworn on the 19th of October 2022, in response to Nairobi Nairobi EC petition number E170 of 2022, and next to the affidavit of the first petitioner in this consolidated petition. That affidavit sheds some light on the process of creation of the new Office of CAS and the public participation. It is not lost on us, however, that events were then at preliminary stages, and in fact, the advertisement seeking public views on the proposed office became the subject of the suit in the ELRC case. We have closely analyzed the newly created Office of CAS. The office falls somewhere between 2 constitutional or state offices, that of the Cabinet Secretary, CS, and that of the Principal Secretary, PS. Those 2 officers undergo vetting and approval by Parliament, but the CASs have been appointed and sworn into office without parliamentary approval. According to the opinion of the Speaker of the National Assembly, there was no statutory or legal framework for Parliament to vet the new 50 CASs under the Public Appointments Parliamentary Approval Act 2011. We are aware that not every holder of high or state office undergoes parliamentary approval. But the problem here is that the CASs are, for all purposes, assistant cabinet secretaries, reporting directly to the ACS. The PS is relegated to the position where he reports to the CAS and the CS. Doubt is completely removed by their job description in Gazette Notice number 12432 of 12 October 2022, and duties specified therein, and the fact the CAS will be in a higher job group, CSG3, than the PS. The Gazette Notice gave particulars of the office as follows: duties and responsibility. A Chief Administrative Secretary will be responsible to the Cabinet Secretary in the performance of his or her duties. Specific duties and responsibilities shall include: A, responding to issues/questions touching on the portfolio assigned to the office. B, providing liaison with the National Assembly and Senate. Providing liaison with county governments on matters of concurrent mandate. Providing interministerial sectoral coordination. Representing the Cabinet Secretary at any meeting as instructed by the Cabinet Secretary. And D, executing any other duties and responsibilities specifically assigned to the office by the Cabinet Secretary in furtherance of the interest of the ministry. Terms of service. A Chief Administrative Secretary will serve on contract as determined by the appointing authority. B, this position is graded at CSG3 in the public service. The remuneration and benefits commensurate to this level will be applicable, unquote. We also find that whereas His Excellency the President can establish a state office within the ranks of the public service, it requires approval by the National Assembly. Such approval may be achieved by enactment of a statute which provides for the same and further provide an appropriate framework for a cap on the numbers of CASs if necessary. In the end, we are not satisfied that the newly created office of CAS meets constitutional thresholds. Having reached the above conclusion, we are nevertheless still minded to address the issue of numbers. We note that the initial approved complement rose from 23 CASs to 50. By virtue of their salary and hierarchy, we agree with the fourth petitioner that the creation of the offices would come at a substantial cost to the public. The respondents urged us to find that the office is separate from numbers, and that once the office was legally in place, it was beyond the court to look into the numbers or the accompanying wage bill, and that the task fell to other bodies such as Parliament, Controller of Budget, or the Salaries and Remuneration Commission. We have addressed that issue in a separate part of this judgment. The respondents and interested parties urged us to find that once the office of CAS was established, the complement, all number of officers, was at the discretion of either the PSC or His Excellency the President. Our attention was drawn to the case of the Judicial Service Commission, which recently advertised for 6 posts of Court of Appeal judges but hired 7. We distinguish the above example from the present scenario on the basis that at the material time there was a vacancy, and JSC did not overshoot the ceiling of 30 judges set for the Court of Appeal. The respondents and interested parties also relied on the decision in Sheria Mutaani na Shadrach Waboi Supra. The petitioner, in that case, challenged the employment of 350 persons by the PSC for the position of Accountant 2 in the National Treasury, but when the advertised vacancies were only 250, the petition was dismissed. But that decision can be distinguished for 2 reasons. Firstly, in the instant consolidated petition, the office created is a high public office with substantial salaries and perks. And secondly, the Sheria Mtaani case was dealing with hiring of lower cadre of public officers, being accountants too. As we pointed out earlier, in interpreting the Constitution, this court is bound to adopt a purposive approach which seeks to give effect to the true purpose of legislation, unquote, and may examine, and I quote, material that bears upon the background against which the legislation was created. See Gatirao Peter Munya versus Dixon Mwenda Gideji. Kenya had for many years a cabinet consisting of ministers and assistant ministers whose composition or numbers was largely at the discretion of the president. The public clamor for control of the size of the executive was reflected in the draft Constitution of Kenya 2005 by the Constitution of Kenya Review Commission. In the proposed Constitution of Kenya 2005, adopted at the Bomas Constitutional Conference on the 15th of March 2004, it was provided for as follows. The President, in accordance with this Constitution, shall appoint and may dismiss A, the Cabinet consisting of 1, the Prime Minister, 2, the 2 Deputy Prime Ministers nominated by the Prime Minister, 3, not less than 15 and not more than 20 ministers nominated by the Prime Minister, and then B, not less than 15 and not more than 20 deputy ministers nominated by the Prime Minister. The number of assistant ministers in the proposed constitution thus matched that of the ministers. Murima J, in the Okia case, had also the following to say on that subject, and I shall not read it. The final report of the Committee of Experts, dated the 11th of October 2010, notes that Kenyans wanted, and I quote, that there be a clear distinction between offices of state and offices of government, unquote. Following public debates, the position of the Assistant Minister was abolished altogether and did not make it to the Constitution of Kenya 2010. It is thus not surprising that the size of the cabinet secretaries is now capped at 22. Article 152 of the Constitution provides that the cabinet shall comprise of A, the President, B, the Deputy President, C, the Attorney General, and D, not fewer than 14 and not more than 22 cabinet secretaries. It is therefore our considered view that the creation of a similar office to the Assistant Minister, now in name of CASs, cannot be created in the manner the first respondent and the fifth respondent proceeded. Based on the reasoning set out above, we do not think that it was the intention of the framers of the Constitution to have 50 CASs deputizing 22 cabinet secretaries. Furthermore, public participation on the office of CAS was founded on a complement of 23 CASs. Doubt is erased by the following other facts. In the letter of 11th October 2022 by Dr. Joseph Kenywa, Head of Public Service, to the PSC, the Head of State requested the PSC to declare 23 vacancies for CASs. We note, however, that the special issue of Kenya Gazette Notice number 12432, dated 12th of October 2022, and the media advertisement the following day calling for applications from suitable candidates did not set the number of vacancies. Furthermore, the stay in the Court of Appeal preserved the original office created on 24th January 2018. Once that office was abolished on 21st September 2022, the newly created office and complement of 23 office holders could no longer benefit from that stay. Accordingly, the newly created office and fresh complement of 50 had to comply with the Constitution and the criteria set out earlier in Okia's case in order to be lawfully established. They did not comply. For the avoidance of doubt, the entire complement of 50 CASs is therefore unconstitutional. I'll now ask my learned sister, Lady Justice Ongudi, to deal with the next issue.
So the next issue is on the financial implications of the creation of this office and whether the same is a waste of public funds contrary to Article 10 of the Constitution. We have already considered the submissions of the first and fourth petitioners on this issue as set out above, as well as the responses by the second and fourth respondents and the first interested party. We take note of the first petitioner's argument that the advice given by the fourth respondent to the fifth respondent in respect of the remuneration and benefits for persons appointed to the office of CAS was inaccurate and misleading. This was due to lack of information as to how many positions would be created. On the other hand, the fourth petitioner argued that the appointment of CAS is a waste of public funds and resources in the face of the high unemployment levels and economic recession facing Kenyans, that the payment of such salaries ran counter to the provisions of Article 10 of the Constitution with specific regard to public funds, resources, good governance, transparency, accountability, and sustainable development. The first petitioner argued that the fourth respondent did not give advice on the financial implications in creating the office with a complement of 50. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230(4)(a). Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022. The second respondent submitted that the legislature has the power over public finance and the independent offices of the Control of Budget and the Auditor General to report to it. These are the offices that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CS was issued within their constitutional mandate under Article 230, Subarticle 4(b) of the Constitution and Section 11 of the SRC Act, and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution, and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4, and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CSS or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. We referred to Article 230, Subarticle 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Ramogi in the Okia case found that failure to involve the fourth respondent on the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honored brother, Justice Alim Fisram, to deal with the next issue.
The next issue is, was the President improperly enjoined as a party to the proceedings? The second to the fifth respondents submitted that the first respondent was improperly enjoined the present consolidated petition. The petitioners on their part did not oppose the said prayer, but contended that the misjoinder was not fatal to the consolidated petition. Having considered the submissions of the parties on this issue as set out above, we are guided by Article 143 of the Constitution and the decision of the Supreme Court in, and I will not read the full citation, but more commonly known as the BBI case, where at the following paragraphs the court stated as follows, and here I will only quote the relevant paragraphs because we have quite a long quote. Anybody or any party aggrieved by the President's actions or failures can initiate proceedings against the Attorney General, who by virtue of being the legal representative of the government in legal proceedings also represents the President, who is the head of government. The immunity, on the other hand, offers protection that shields the President from civil suits being filed against them in their personal capacity. I will further quote, as such, pursuant to Article 156.4 of the Constitution, the exercise of public power by the President can be challenged in a court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein the court may issue appropriate reliefs. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143.2 of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the office of President during their tenure of office in respect of anything done or not done contrary to the Constitution. Pursuant to Article 143 of the Constitution and based on the law as set out above, we find that the first respondent was improperly enjoined to the consolidated petition. We further find that the misjoinder is not fatal to the consolidated petition, but take the opportunity to urge the petitioners and future litigants to avoid this practice in light of the unequivocal pronouncements by the Supreme Court on this issue.
Thank you. I'll now ask the Honorable Lady Justice Hedu Gangudi to deal with the next issue.
The next issue is whether the consolidated petition was drawn with sufficient precision. In a constitutional suit, a party that alleges violation of his or her rights must plead with reasonable precision the manner in which the rights have been violated. We have a number of authorities on this. And our interpretation of the above provision is that for a constitutional petition to be sustainable, it must satisfy the threshold set out in the authorities we have cited. It therefore follows that the mere citing of constitutional provisions is not enough. The petitioners must, with some reasonable degree of precision, identify the constitutional provisions that are alleged to have been violated and the manner in which the said provisions have been violated from the facts and the evidence of the case. In the circumstances of this case and material placed before this court, we find that the above threshold has been met by the petitioners. And the next issue is on unpleaded issues raised in submissions and supplementary affidavits. The second and fifth respondents and some interested parties opposed the introduction of new issues and new prayers as raised by the third petitioner in its supplementary affidavit dated 5th of May 2023 and the second petitioner's further affidavit dated 2nd of May 2023. The second respondent submitted that new issues were also added in the submissions of the second and third petitioners in paragraphs 39, 54, 56, and 56. The fifth respondent challenged paragraphs 14 to 20, 29 to 31, and 43 to 50 of the third petitioner's supplementary affidavit, and paragraphs 29 and 33 of the second petitioner's further affidavit. The second to 7th, 9th to 18th, 20th, 21st, 23rd, to 30th and 33rd to 51st interested parties also challenged the admissibility of evidence in paragraphs 13 to 17 and 33 of the second petitioner's further affidavit, and paragraphs 18 to 33 and 36 in the supplementary affidavit of the third petitioner. The 19th interested party also challenged the admissibility of the evidence in paragraphs 14 to 20, 29 to 31, 33, 43 to 50, 59 to 61 of the third petitioner's supplementary affidavit. Counsel emphasized that the record should reflect that they had no opportunity to reply to the new allegations and had not admitted to the contents of the impugned paragraphs. We have referred to the Supreme Court case in Raila Amolo Odinga and Stephen Kalonzo versus IEBC and others, and also the Court of Appeal case in IEBC and another versus Stephen Mutinda Mule and 3 others. We are satisfied that the second and third petitioners tried to introduce new issues that were neither pleaded in the original petitions but were found in their further affidavit, supplementary affidavit submissions, and also found in the amended petition filed out of time, which the court declined to admit. Evidently, each party is at liberty to frame his case in his own way while paying regard to the rules of pleadings, and in the end is ultimately bound by the manner in which the pleadings were drafted. As such, a party cannot be allowed to raise a different or a fresh case without an amendment to the pleading. The court record reflects that the third petitioner's request to extend the time within which to file and serve the amended petition was declined. Taking this into consideration, we have confined our decision to only the matters properly pleaded before this court and as captured in the issues we framed above.
Thank you, Lady Justice Omudi. At this point, what we have been reading are contents of the majority opinion. At this point, I'll ask the Honorable Lady Justice Hedugangudi to read her judgment.
So I have considered in detail the majority decision in this consolidated petition, the factual background, the summary of the submissions advanced by the parties, as well as the issues for consideration and determination as framed. I'm in agreement with most of the issues in the majority judgment. These issues are the jurisdiction of this court, res judicata, public participation, enjoyment of the President and the control of budgets, and lastly, the financial budgetary estimates. I, however, differ with the majority on 2 issues. Namely, 1, whether the office of CAS was constitutionally established, and 2, whether the 50 CSs were appointed in accordance with the law. The office of the CAS was first established in Kenya on 24th of January 2018 by the former President Uhuru Kenyatta. He subsequently nominated and appointed the CSs alongside the cabinet secretaries and the permanent secretaries. This decision was soon after challenged in the Okiya Mtata case. And on 20th of April 2021, Justice Mrima rendered his judgment in which he declared the establishment of the CS office unconstitutional. The orders issued are found at paragraph 309 of the said judgment. A perusal of the 5th respondent's CEO Simon Rotich's response in the ELRC petition number E174 as relied upon by the first respondent in the instant consolidated petition indicates that a while later, on 19th of September 2022, the PSC received a letter from the then head of public service, Mr. Kinyua, informing it of the President's proposal on the establishment of the office of the CS in the public service. In brief, the letter set out the history of the office and the justification for its establishment. Equally, the President proposed that the office of the CAS be ranked in the public service within job group CSG3. Further, that one position be established in each ministry, except in the Ministry of Interior and Coordination of National Government, that would have two positions in light of the scope and significance of its portfolio mandate. The letter as well listed the job description of the CAS and relevant qualifications. Based on this, the fifth respondent at its weekly meeting on 21st of September 2022 discussed the proposal and observed that the office had been established in January 2018. However, the process of establishing it had been declared unconstitutional in the Okiya Mtata case for lack of compliance with provisions of the Constitution. Considering the court's decision in the said case, the fifth respondent resolved to abolish the CAS office established on 24th of January 2018, comply with the orders of the judgment in light of the President's request, and conduct public participation. The fifth respondent via a press advert on its website and the local dailies dated 21st of September 2022 invited members of the public to submit their views on the proposed establishment of the said office. And following the call for the public to issue its views on creation of the office, the second petitioner filed the ELRC petition number E174 of 2022 against the fifth respondent for the reason that the advert was illegal for violation of Section 27(1) of the PSC Act insofar as it failed to include fundamental details to enable the public make meaningful and informed contributions towards the establishment of the office. Further, that the advert was unconstitutional for violating Article 201(d) of the Constitution as it seeks to establish an office in the public service with duplicity of roles as that of the Principal Secretary. Justice Mbaru, in the said matter, satisfied that the fifth respondent had complied with the orders issued in the Okiya Mtata case and the dictates of the Constitution held as follows in the judgment dated 16th of February, while dismissing the petition. Upon being satisfied that the creation of the office of CAS is justified, upon being satisfied that the financial implications of creating such offices indicated, and that the office so created relates to or supports the core functions of the public body requesting for its creation, such satisfaction is sufficient for the first respondent. It is its core function under Section 27(1) of the PSC Act, and in this regard, the internal processes for levels for grading, designation, qualifications and remuneration cannot be faulted. The fifth respondent, in its response dated 11th of October 2022 to the President's proposal, informed of the outcome of the public participation exercise, steps taken to comply with Section 27 of the PSC Act, and after making all these considerations, recommended establishment of the office as proposed. Following this conclusion, the office of the CAS was established via a letter dated 11th of October as communicated by Joseph Kinyua, the then head of public service, to the fifth respondent's chairperson, Mr. Mushiri. With this contextual background in mind, it's my considered view that the petitioners in both petitions, that is the Okiya Mtata case and petition number E174 at the ELRC court, were concerned about the legality of the actions of the former and current presidents in establishment of the office of the CAS in light of the dictates of the Constitution. The High Court, as discussed, found that the claim that the processes towards the establishment of the said office was in contravention of the Constitution, as well as sections 27 and 30 of the Public Service Commission Act, which succeeded. The court as such declared the office of the CAS unconstitutional. That is at paragraph 310B of the judgment. This decision in the end formed the basis of abolition of this office and establishment of the new office, whose creation process was affirmed by the ELRC. Appreciating all these factors, this court will now make a determination on this issue as presented by the petitioners and defended by the respondents and interested parties. It is worthy to note and emphasize that the decision in the Okiya Mtata case, as pronounced by Justice Mrima, was stayed by the Court of Appeal. The outcome of the same is a matter that remains unresolved and will inevitably affect the outcome with reference to the office of the CAS in general. On the other hand, the decision in the ELRC petition E174, as determined by Justice Mbaru, was the basis of the fifth respondent's decision to either complete the process of establishing the new office of the CAS or end the same altogether. I say so because from the chronological timelines, it's clear that the fifth respondent did not call for interviews for the CAS position until the ELRC delivered its judgment on the 16th of February 2023. It is further noted that this judgment has not to date been appealed against. Manifestly, the contents of the two decisions arise from courts of concurrent jurisdiction, which legally do not bind this court, as we are of courts of equal status. This was underscored by the Court of Appeal in the case of Bellevue Development Company versus Francis Ikonyo. Be that as it may, this court cannot turn a blind eye to the first and fifth respondents' actions. It is clear that the first and fifth respondents herein, owing to the adduced correspondence before this court, in an attempt to comply with the law and the pronouncement of the High Court, established a new office of the CAS based on the orders issued. This compliance was given the green light by the ELRC in its judgment by Justice Mbaru, which cannot be ignored. This act was in line with PSC's mandate under Article 234, 2A, Roman 1 of the Constitution, which makes known that one of its powers and functions is as follows. The Commission shall, subject to this Constitution and legislation, establish and abolish offices in the public service. My opinion on the preceding point is informed by the Supreme Court observation in the case of Attorney General and two others versus D and 17 others. I've cited the portion there. Evidently, the regularization of the office of the CAS as proposed by the President in the letter dated 19th of September 2022 and recommended by the fifth respondent in the letter dated 11th October 2022, being premised on the rule of law, cannot be faulted. The unavoidable conclusion I come to is that the process undertaken to establish the new office of the CS that endorsed 23 posts as seen from the correspondence was lawful. For that reason, the ensuing determination will only speak to the constitutionality of the additional 27 CAS posts. The office of the CAS, as submitted by the parties, was constituted under Article 132 of the Constitution, which essentially spells out the functions of the President. An answer to this question involves interpretation of this sub-article by applying the pertinent principles of constitutional interpretation, which have been dealt with in the majority judgment but I have referred to the Supreme Court case of Evans, Odhiambo, Kidero, and 4 others versus Ferdinand Waititu, and the case of Communications Commission of Kenya and 5 others versus Royal Media Services Limited. And guided by the law and opine above, I find one of the facets of a holistic interpretation to be an interrogation of the past. Fundamentally, the question is what informed the description of the functions of the President before the promulgation of the Constitution 2010. I've referred to the final report of the Constitution of Kenya Review Commission, which states that on the attributes of the President, they envisioned and noted the citizens' contributions. With respect to the office of the President, that 1, the President should not be above the law. A majority asserted their concerns were that it should be possible to prosecute him or her for offences while in the office. In this regard, it was also suggested that the Constitution provide for the President's removal for misconduct. 2, the powers of the President should be curtailed. Kenyans felt that the President should not have the exclusive power to appoint senior government officers. It was suggested that for many of the appointments be vetted by Parliament, and that the President should not have the power to determine the election dates. Now, the Commission on this point concluded as follows at page 199. The Presidency, the head of state, must be more than ceremonial. He or she should have reasonable powers. However, those powers should be limited. Excess powers upset the internal balance within the executive, and the principal function of the Presidency would be to symbolize national unity and promote national integration, security of state, and protection of the Constitution. So it's clear from the historical point of view that Kenyans were keen that the President should have limited reasonable power that is exercised within the confines of the law. And turning to the attributes of the 5th respondent, which was categorized under the organs of the government, the committee at paragraph 13.65 under chapter 13 revealed as follows. It is clear that what the people were asking for was the re-establishment of principles of public service, neutrality, impartiality, and independence. The people of Kenya want to see appointment processes that are transparent and offices that are not only accountable to the people but also capable of guarding public wealth and resources. So out of this conclusion, one of the first recommendations made by the committee was for the establishment of an independent public service commission. Article 132(4)(a) of the Constitution provides that the President can create an office in the public service in accordance with the recommendation of the 5th respondent. To my mind, the intention of this sub-article was to limit the President's power to create an office in the public service to the extent that the creation must be done in tandem with the 5th respondent's recommendation. The recommendation must basically be guided by the edicts of the Constitution and the law. It is apparent, therefore, that the two conditions as conceived were intended to be inseparable and work in harmony. This, in my view, was the intention of the drafters of the Constitution and the aspirations of the Kenyans. With this background in mind and principles of the constitutional interpretation, the question that crystallizes is whether the additional 27 posts in the office of the CS were properly constituted in light of the Constitution and the law. To answer this question, I will first examine how a public office under this article is established, and with reference to Article 132(4)(a) of the Constitution, the Public Service Act under Section 30 provides as follows. Recommendation to the President. 1. where the President, under Article 132(4)(a) of the Constitution, requests the Commission to recommend the establishment of an office in the public service, the Commission shall act in accordance with the conditions provided for in this part. And then the conditions of establishment of an office in the public service is clearly provided for under Section 27 of the PSC Act. Fundamentally, for an office established under Article 132(4)(a) of the Constitution to be properly constituted, the same must satisfy the threshold set out under Section 27 of the Public Service Commission Act, as read with the provisions of Articles 10 and 232 of the Constitution. The number of persons that can be recommended for this position is not expressly stated in the Constitution or the PSC Act. Similarly, the requirement for approval of the National Assembly for the CSS position is not provided for. What is clear is that any post that is established must comply with the principles of the Constitution and Section 27, as read with Section 30 of the PSC Act. A look at the material before this court reveals that through the affidavit of Felix Koskei, the head of public service, dated 24th of April 2023, that on 23rd of February, the President wrote to the fifth respondent seeking a review of the complement of CS within the public service to vary from 1 in each ministry to 1 in each state department. On the same day, the fifth respondent CEO, Mr. Rotich, wrote to the PS, Chris Kipto, seeking concurrence on the availability of funds to meet resultant expenditure on the additional posts of 27. The fifth respondent, in response to the President's letter, consented to this variation in its letter dated 27th of February. In the letter, the fifth respondent noted that the consent was based on workload attendant to the role of the CS and National Treasury's confirmation of funds. Following this communication, the President increased the complement of the office with an additional posts and asked the fifth respondent to recommend persons to be appointed, which it did. Additionally, in response to a letter dated 18th October and 2 letters dated 10th March 2023 by the fifth respondent, SRC wrote a letter dated 14th March to the fifth respondent advising it on the job valuation, grading, and remuneration and benefit structure for the said position. Soon after, the 2nd to 51st interested parties were nominated on 16th of March and appointed by the President on 23rd of March. From the letter dated 23rd of February 2023, it's discernible that the nature of the office of CS varied drastically. In the initial letter dated 19th of September 2022, the proposal was for 1 position in each ministry, except in the Ministry of Interior and Coordination, while in the letter dated 23rd of February, the proposal was a review of the complement of CS within the public service to vary from 1 in each ministry to 1 in every state department. This letter introduced a new element in the office that was not accounted for in the previous process that was found to be lawful. Furthermore, despite this vital additional aspect, the fifth respondent went ahead to make a recommendation without seeking further information and justification as required under Section 27 of the Public Service Commission Act. Likewise, the sequence and procedure that led to the establishment of the 27 additional CS posts did not involve adherence to the constitutional principle under Articles 10 and 232 of the Constitution. I therefore find that the manner of establishment of the additional 27 posts in view of Article 132(4)(a) of the Constitution, Sections 27 and 30 of the Public Service Commission Act, and the necessity of the fifth respondent's recommendation was unconstitutional. On the flip side, I find the establishment of the CS office in the public service with 23 posts to be constitutional. The orders will be as proposed in the majority judgment.
Thank you very much, Lady Justice Hedi Bungudi. I'll now ask my learned brother, the Honorable Justice Alim Fisram, to deal with two of the remaining issues before we pronounce the final orders.
The next issue is what is the constitutionality of Section 26(2) of the SRC Act and the SRC Remuneration and Benefits of State and Public Officers Regulations 2013. Having considered the submissions of the parties as set out above, we take note that the central arguments made by the petitioners in relation to the above issue are as follows. First, that the fourth respondent refused to discharge its constitutional duties and defend its independence on behalf of the people of Kenya from the unconstitutional encroachment and interference by the National Assembly as evidenced by the enactment of Section 26(2) of the SRC Act. Second, that the fourth respondent failed to undertake compulsory public participation in the process that resulted in the enactment of the SRC Remuneration and Benefits of State and Public Officers Regulations 2013. In response to the above, the fourth respondent submitted that it undertook extensive public participation relating to the impugned provisions, and that the same is evidenced in its annexure collectively marked as ARG3 in the replying affidavit of Ms. Anne Gitau. However, and more importantly, it submitted that while the provisions of Order 3, Rule 5 of the Civil Procedure Rules and the Constitution of Kenya, protection of fundamental rights and freedoms, Practice and Procedural Rules 2013, do permit the joinder of causes of action, the issue of the creation of the position of CAS and the subsequent appointment of the second to 51st interested parties as CASs, and the issue of the constitutional validity of Section 26(2) of the said Act relating to the advice and remuneration and benefits of the CASs are independent and distinct causes of action. Further to the above, the issues do not arise out of the same act or transaction or series of acts or transactions, and no common questions of law or fact would arise should these two issues be considered together. The two causes of action joined in the petition are fundamentally disparate in nature, both legally and factually. Each cause of action carries distinct elements, legal standards and remedies, necessitating separate and individual consideration. The fourth respondent contended, and we agree, that by joining these unrelated causes of action, this court may not be able to render a fair and efficient resolution of that particular issue, given that it derogates from the core issues before this court. This court is of the view that in order to ensure efficient administration of justice, each cause of action ought to be litigated independently to ensure the proper application of law, presentation of evidence, and resolution of disputes. In the present matter, this court has not had the sufficient opportunity to carry out the above exercise in relation to that specific issue. Accordingly, and based on the reasons set out above, we decline to entertain this issue and find that the same is an unrelated cause of action within the context of the consolidated petition. The petitioner is, however, at liberty to raise the issue as a separate cause of action should it wish to pursue the same. The next issue is whether the controller of budget was improperly enjoined as a party to the consolidated petition. Having considered the submissions of the parties as set out above, we note that the crux of the first petitioner's case with respect to the first interested party is as follows. A. That the first interested party oversees the implementation of the budget of the national and county governments by authorizing withdrawals from public funds under Articles 204, 206, and 207 of the Constitution. B. That the first interested party is prohibited from approving any withdrawal from a public fund unless satisfied that the withdrawal is in accordance with the law. C. That the first interested party would be required to approve any withdrawal of public funds to pay remuneration and benefits of persons appointed in the office of CAS for which there is currently no lawful authority. Based on the above, the petitioners enjoined the first interested party, presumably because they were concerned that it may make payments of remuneration and benefits to the CASs which are not authorized by law. In responding to the above concerns and regarding the assertions made by the petitioners, the first interested party clarified that its responsibilities do not involve paying remuneration and benefits to the CSs or any other state or public officers. The mandate of the Controller of Budget under Article 2284 and 5 of the Constitution is to grant approval of withdrawal of funds in accordance with the law and not to effect payments on specific transactions. It is the responsibility of the relevant accounting officers to pay remuneration and benefits to the respective members of staff. The fourth respondent accordingly submitted, and we agree, that it ought not to have been enjoined in the present proceedings. We have looked at the consolidated petition, and we find that no cause of action has been disclosed against the first interested party. Further, the petitioners have not sought any specific orders against the first interested party, nor have they set out in detail any specific violations of the law demonstrated by the first interested party.
Thank you very much, Judge Alim Fisram. Before we conclude our judgment, we are constrained to comment about the conduct of counsel for the third petitioner, Mr. Ochiel Dudley. On 19th of June 2023, he authored a letter addressed to the Deputy Registrar titled Professional Duty to Disclose, requesting the Deputy Registrar to bring to our attention a recent decision of the Supreme Court whose findings would aid us to deal with the present consolidated petition. At the time of the letter, the proceedings had been closed and a date for judgment set. We thus found the conduct of Mr. Ochiel inappropriate. For obvious reasons, we did not refer to the decision he referred to, and it was not necessary to do so. These are our final orders. Having answered all the issues that we framed in the consolidated petition, we now make the following final orders. A, that the current Office of Chief Administrative Secretary, created by the first and fifth respondents and contained in the Kenya Gazette Special Issue number 12432, dated 12th of October 2022, and which announced the vacancies thereof, is unconstitutional. B, that whereas there was some reasonable public participation on the first complement of 23 Chief Administrative Secretaries, there was no such participation regarding the additional complement of 27 office holders. C, that the entire complement of 50 Chief Administrative Secretaries, which is to say all the second to the 51st interested parties, is unconstitutional. D, for the avoidance of doubt, the notification by the first respondent dated the 16th of March 2023, appointing the second to 51st interested parties to the office of Chief Administrative Secretary is hereby quashed. E, that the prayer that Section 26, subsection 2 of the Salaries and Remuneration Commission Act and the Salaries and Remuneration Commission, Remuneration and Benefits of State and Public Officers, Regulations 2013, be declared unconstitutional is disallowed. F, a declaration is hereby issued that the first respondent enjoys constitutional immunity from suit and was illegally joined into the proceedings. G, that the petition against the first interested party, Controller of Budget, is hereby dismissed. The last issue relates to costs. Costs ordinarily follow the event and are at the discretion of the court. We find that the consolidated petition raised constitutional issues in the public interest. The order that commends itself to us is that each party shall bear its own costs. Thank you. Thank you, Dr. Kamodo. If you can give us just 1 minute to sign our judgment.
Shall I ask Mr. David, the President, to plead my case for Kenya?
All right. Now, Dr. Kamodo.
Yes, my lord, we are enormously grateful for the well-reasoned decisions that the court has rendered.
Yes.
And we will be requesting for copies of the judgment at the earliest stage, as well as the proceedings. Further to that, we'll be making an application for the stay of the decision of the majority to enable us seek a second view at the appellate court seeking for a stay of 60 days, which we believe is sufficient to enable us to process the proceedings and to prepare a proper record of appeal for delivery at the Court of Appeal. And this is founded on the reasons that we believe we have reasonable grounds of appeal first. We will be raising a question of jurisdiction at the appellate court. And just like the Honorable Court was able to arrive at different findings, we will also be seeking answers partially to some of the issues that have been decided, including the question of public participation, which in our view will be arguing that it was adequate. We believe it is necessary that a stay be granted because as we start now, we believe the court has properly laid it out that it cannot interfere in any way with the decision of the employment court in ERC number E174 of 2022, and therefore, as we speak, the first respondent is at liberty to appoint 23 CSs, but we'll be pleading the case for the extra 27 when we get to the Court of Appeal, because we believe that the respondent, the interested parties, would be constitutionally entitled to the right of appeal, which would be fundamentally obliterated if a stay is not granted. It will also be necessary that the various competing decisions of courts of coordinate jurisdiction including the majority and minority decisions are harmonized, and our only port of call is at the Court of Appeal. And given that we are persuaded that we have an appeal that is promising and stands high chances of success, we'll be praying that the court be pleased to stay the orders issued today to enable the interested parties get a final position as would emerge from the Court of Appeal. I'm grateful, my Lord.
Thank you, Dr. Kamotho. All right. Is there any other counsel joining in the application by Dr. Kamotho? Let us know.
To the issues raised by Dr. Kamotho. My Lord and my Lady, you will note that the issues raised in this matter are fairly heavy. Not just heavy for the interested parties and the respondents, but for all the Kenyan people who also desire and who benefit from the services that have been rendered and are supposed to be rendered by the CDSs. My Lord, my Lady will also note that the issues were heavy to the point that even your Lordships have been unable to take a common position on all of them. It is therefore, in my humble submission, fair that we interrogate these issues further, as we are lawfully entitled to, before a final position can be taken on the matter. My Lord and my Lady, you will note further that there is another decision by a court of concurrent jurisdiction that is being affected by this decision, given that the position taken by the majority decision is not on course with the position that has been taken by the Employment and Labor Relations Court. It would therefore be proper that any adverse implications of this decision be stayed temporarily so that finality can be achieved on some of the issues. Lord, my Lady, and that we believe will not be too much, and besides, it will be in the best interest of justice.
Thank you, Dr. Arwa. Mr. Wanyama?
Yes, my Lord. I also agree that the peculiar circumstance of this matter, from a public policy standpoint, especially on the fact that there's a decision from the Employment and Labor Relations Court. We have the Murima decision. And then now you have this bench majority decision. Ordinarily, members of the public would want consistency on what is coming from the courts. And the best way to resolve that question of conflict, apparent conflict of decisions from the courts is through the appellate mechanism. And public policy will then support that approach. My proposal will be that given that the status, a stay of 90 days as opposed to 60 days. The 90 days will be sufficient enough to warrant an interrogation even at the preliminary stage at the Court of Appeal on that question for this prudential stability. On the question of prejudice, the petitioners don't suffer prejudice if stay is granted for that fundamental question to be interrogated. The reason is that this is a matter which is a decision in realm. Therefore, they have no nexus, as it were. It benefits the public if the Court of Appeal determines that question. So we'll be asking for 90 days. Thank you.
Thank you, Mr. Anyama.
Yes, my Lord.
Yes, Mr. Bita.
I wish to join the application seeking a stay of the decision of the Son of the Court. My Lord, the first point I'll make is that the court has jurisdiction to issue the order sought. It is within your purview. The second point, my Lord, is that from the perspective of rights of the interested parties, my Lords and my lady, this dispute touches on fixed term contracts, and which, if the decision of the Honorable Court is to take effect, is not reversible. And may severely affect the right to appeal, to more or less take it away or limit it. And therefore it is important to preserve the substratum of the appeal and the rights of the interested parties as they seek it. My Lord, you're aware that this being a court of first instance in constitutional litigation, parties have constitutional rights to pursue their appeal, and therefore we're seeking a stay to facilitate the exercise of that constitutional right. I think that would be all in terms of supporting the application. My Lord, I will support 90 days because, my Lords and my lady, you're aware we have an intervening court vacation, and for all practical purposes, it may not be practical to have a similar application filed and determined within the month, noting that the cause list in the Court of Appeal is usually a monthly cause list. So in light of that fact, we believe that a longer period of stay would will not render the exercise of that request to allow the parties to pursue an appeal negative.
Thank you, Mr. Bita. Mr. Noura, you want to add something?
Yes, my Lord. I think it would be remiss of me if I don't add anything, having a majority of the clients in this matter. They might as well fire me if I don't comment. So, my Lord, just to add on what Mr. Bita and Mr. Wanyama have stated, the court, in its judgment, in delivery of its judgment, raised in the preliminary or at the beginning, at the commencement, an issue of neatness with several other judgments that have been issued by courts of concurrent jurisdiction. So, as it stands, we have a decision in E174, the Mirima decision, an appeal pending in the Court of Appeal, a decision in terms of stay given by the Court of Appeal, the majority decision of this court, and the dissenting decision of this court. So it is my opinion that before we started, where we started and where we are right now, in terms of neatness, we are worse off, with 5 decisions that are hanging. It is important that we have uniformity from the Court of Appeal, and that can only be possible if this court grants a stay of 90 days for us to be able to appeal. I completely agree with the Learned Counsel Wanyama that 90 days would be sufficient for us to approach the Court of Appeal and get uniformity of these decisions. Just to emphasize on the importance of the stay, my clients, who are around 46 of the chief administrative secretaries are persons who have already been sworn into office. And what was pending is an order of this honorable court staying or stopping them from conducting their duties as chief administrative secretaries. Should the orders of the court today take effect, essentially that would be reversing the same, and it would not allow them an opportunity to appeal. It would completely destroy the subject matter of the appeal. So therefore, my lady and lord, I pray that this honorable court grants a stay for 90 days to allow it. That is it.
My lords and my lady, I wish to associate myself with the submissions of the Attorney General and my learned friends, Mr. Wanyama, Dr. Kamotho, Mr. Arwa, and Mr. Nuda. My lord, but I wish to state that if for any reason whatsoever you do not find it fit to grant a stay, I would plead that at the very least you grant a stay on your finding on the 23 CAS positions. My lord, I wish to submit that it is in your judgment that there was some form of public participation for the 23 positions. It is also in your judgment, and you agree that the Public Service Commission abolished the first CAS positions that were established in the year 2018. My lord, the petitioners will not suffer any prejudice should the 23 positions be, the position on the 23 positions be stayed. Because my lord, as is clear from the petitions, the greatest challenge was on the additional 27 positions. We urge you, my lords and my lady, to save the 23 positions by way of an order of stay. And I do submit that 90 days stay would be sufficient to enable us to pursue the matter in the Court of Appeal. I submit, my lord.
Thank you, Ms. Malani. Any reply from the petitioners? Mr. Ogada.
Your Lordship, thank you very much. Mr. Matindi has made me aware that he is not able to communicate to the court. I bring that to the court's attention. Perhaps he will be allowed to speak if he has anything to say. On behalf of the second petitioner, the Law Society of Kenya, the application for stay is proposed for the following reasons. The court will note that there has been a stay, and that stay is still in existence. The terms of the stay orders were to the effect that all nominees were barred from exercising any capacity with regards to the CAS office. Those orders are in place. So the argument of prejudice cannot suffice. There is an existing order. We heard it from the other side that services were being rendered by CASs. That will be an interesting twist. We'll want them to bring evidence of the services that were being rendered by these CASs so that we can respond. In a nutshell, we want a formal application brought so that all petitioners can respond. Because when you say services were being rendered contrary to existing court orders, it is a requirement in equity that you come to court with clean hands. And therefore, if services were being rendered contrary to court orders, the petitioners will have enough to say. Third, when an act has been declared unconstitutional, as has been declared by this court, This an order for stay cannot reverse that position. Stay can only be on the execution, but a declaration of unconstitutionality can only be reversed on appeal. So we urge them to please exercise their right of appeal, and the petitioners will meet them there. We also heard that prejudice will be suffered by the other side because the courts are going to vacation. We all are aware that the Court of Appeal has a duty judge on vacation. There are vacation rules that allow the filing of applications under those rules. Therefore, let them file here, give the petitioners an opportunity to respond to formal filing. We are also told by the other side that there is need for uniformity for the myriad of decisions that they claimed. We urge them again. Let them go make that argument on the merits, and the petitioners will be ready to deal with them. And therefore, the position for the LSK is that we object to that application of stay. Let them file something formal. We will be ready to deal with it. Thank you.
If I may respond.
If the Lordship allow me also to voice my concerns and supports to...
Okay. Can we hear the Mr. O'Shea for the third petitioner? Are you saying anything? All right, then he has yielded to you, Mr. Mature. Proceed.
So could I say something about
you did not seem eager to say something.
I was still thinking about the court's earlier order, which is the only bit of the decision I would concede to a stay on. Nonetheless, my lord, allowing the stay as requested would mean that the dissenting opinion becomes the majority opinion because it would remain the statement of law. So we request you to reject the application for stay. Also because it would mean that all the things that the majority decision or the court's decision has found, because the majority decision becomes the decision of the court, do not exist. It would be as if you did not find the appointments unconstitutional, you said nothing about the impact on the public purse and the burden on the taxpayers. So reject the application. If they insist on it, let them make a formal application that we can interrogate and look at. And being my first opportunity to speak, my lord, allow me to request Mr. Theory to address the court concerning my performance of the duty to disclose a recent and relevant and binding Supreme Court decision that as advocate I am bound to disclose. I disclose it, the court finds my conduct inappropriate.
Completely inappropriate. But now, Mr. Shea, we are dealing with an application for stay. The matters of discipline fall in another body headed by your president and certain other bodies. The less we say about it, Mr. Shea, the better. Mr. Mature.
Your Lordship also allow me to side with the comments in opposing the application for stay. Firstly, on account of the fact that having rendered your decision, it is my considered opinion that you have become functors official. It is therefore not open for you to issue any orders that may seem to countermand the same decision that you rendered today. In the event that the respondents and interested parties like desires of moving to appeal as they have indicated, they will make a formal application so that us, the petition, has also given a chance to respond on the application on merits. That shall be all.
Thank you, Mr. Mature. Now, Mr. Arrow, if it is a response, I would have to go back in the original order. I would ask Dr. Kamodho to speak, followed by you, Dr. Alwa, and then Mr. Wanyama. And I'm not encouraging you to speak, just in case you feel seriously that you need to say something, then Mr. Bita, Mr. Nura, Ms. Manani, and Mr. Ogadel in that order.
Thank you, my Lord. First, briefly in response to...
And shall we give this guidance? Now that this is an oral application for stay,
Yes.
which is opposed, and you are now replying, if you could confine your reply as much as possible now to matters that can guide us on the law. Thank you, Dr. Kamoto. Proceed.
Yes, I will squarely do that, my Lord. So, we reiterate that our plea for stay is well-founded, despite now the issues that have been raised by the other side. First, because it's not the initial time that the court has taken such route. When the Honorable Justice Murima found that there were some infractions in the Okia Umtata versus PSC case, he provided for an inbuilt stay for regularization of what the court had pointed out. Because part of what the court exists to do is to offer guidance so that as institutions keep growing, they benefit from the wisdom of the court. So in that case, the Honorable Justice Murima allowed the CASs to remain in office, despite the finding that there were issues that touched on the constitutionality. And the current matter before you, my lords and my lady, is equivalent in character. And we would, as much as you have borrowed from the jurisprudence in that decision by Honorable Justice Murima, we urge that you find it appropriate to grant an inbuilt stay mechanism to facilitate for the next course of action that we intend to pursue. Further, my Lord, the Court of Appeal itself, when the matter reached the Court of Appeal in civil application number 131 of 2021, now being PSC versus Omtata, the court did grant a stay. It allowed the CASs to continue delivering services, offering services, because I can persuasively state that the purpose of having the CASs is to ease on the burden that is currently bedeviling the CSs. They are only 22 in number, so many duties, and that impairs their efficiency levels. So they need more hands on deck to aid service delivery to Kenyans. It must not be perceived that the CASs are deeply craving and hungering for positions for aggrandizement. I believe the reverse is true, that they are eager to offer services in the offices that have been appointed to. There was an issue pointed out by Mr. Oganda that the stay orders are still in force, but I believe those were orders pending the hearing and determination, which have now lapsed and start spent.
Yes.
We have, it has been stated that we are seeking to reverse the decision so that the majority becomes a minority decision. I believe that is farthest from the truth, because what we are seeking is just a stay, and stay is provided for. A stay of execution is provided, well provided in law, and this court still has jurisdiction on this matter. It remains the only proper judicatory forum for the time being until justice to the parties is finally settled, and therefore the question of being franked as official does not lie. The court still has mandate to grant the relief that we are seeking, and we fervently pray that the court considers the plight, not just of the interested parties, but the plight also of the citizens who would start benefit from the services of the extra 27 CSs whose status remains uncertain. And at that point, my Lord, I wish to rest my submissions and allow my colleagues to carry on. Thank you so much.
Yes, Mr. Arwa.
Lord, my lady, in brief response, I would wish to state first that the request for stay is actually within the jurisdiction of this court, and is actually anchored on the provisions of Section 3A of the Civil Procedure Act, 1A, 1B of the same Act. This section citing empower the court to do what the ends of justice demand. And it is my humble submission, Lord and my lady, that the ends of justice in this particular case demand that the decision of the majority be stayed pending the appeal. Lord, that particular order would be in the public interest. And it is our humble submission that public interest is implicated in this matter at several levels. First, and as I previously indicated, the public is interested in the services that will be rendered by the CSS. It would not be correct to assume that they would only consume public money and not give benefit to the public. And it is the right of the Kenyan public to benefit from the services of the person. And that right ought to be protected. As long as there is an issue, my lord and my lady, that can be determined the other way. Although the public interest is also implicated at the level of the interested parties. There is no doubt that the interested parties have been appointed to a public position. There is no doubt that many of them had actually resigned from their previous positions. And their position has been in limbo for several months now. What the decision that has been rendered today means is that they have no hopes unless the appeal succeeds. Considering that some of them, Lord, had already relinquished their earlier positions. If for nothing else at all, my Lord, at least for that reason, there will be need to grant a stay pending with further interrogation of these issues. My Lord, it's not correct, as my learned friend Mr. Ogada said, that when a declaration of unconstitutionality has been made, then no stay is feasible. That is not correct. These courts have been known, Lord, to make a declaration, but suspend the declaration pending whatever it is the interest of justice to demand. A declaration of unconstitutionality can be made, but we stay pending the taking of some other action as may be necessary. And it is in this light that we are asking you to suspend temporarily to have the issues looked into But there is also the issue of the implication of this disease on the actors that are affected, which we already talked about. And I'm now speaking only about the public interest implications of the state, because it will preserve the integrity of these decisions, these cases that are pending, and which will be affected differently by the decision rendered. So there is a statement by my learned friend Mr. Gada that he would require clarification as to the services that the CSS have been rendering. But when I spoke about the benefit that the public derives from the CSS, I'm not referring to this particular CSS. So there will be no need to do any such clarification. Then there is a statement made that
Mr. Arrow, you need not respond to every statement that Mr. Oganda made. If you can just concentrate on whether a stay should be granted or not.
Just in conclusion, my Lord, I'm just saying that that statement by Mr. Oganda is actually a concession to the need for a stay in this case, considering that whatever stay is referring to was meant to come to an end today. Thank you.
My Lord, I'll be quick. Don't take a lot of time. Lord, if you look at the provisions of Article 23(3) of the Constitution, it's not correct to say that a declaration of unconstitutionality is the end of the matter. The court has jurisdiction under that clause in the Constitution to grant, and I underline, an appropriate relief. An appropriate relief in this case includes a stay order. And listening to the majority judgment, you'll get the feeling that this is one of those special cases where stay shall be granted. The reason is that we have another decision from the Employment and Labor Relations Court, which this court says is not binding to it, and it proceeds to render its own decision. And because of that particular conflict, a situation-sensitive aspect arises which requires determination by the Court of Appeal for jurisprudential stability. And that's the reason why we are pleading for stay for 90 days. Thank you.
Right, then after that I had Mr. Bitter, do you want to add your voice?
Yes, just a few lines. I'll pick up from what my colleague Mr. Wanyama said. Lord, you realize from the architecture of our Constitution that the Constitution contemplates that the High Court can actually make errors in interpretation of the Constitution. And it confers to parties a right to appeal. So that is where we're coming from, that the possibility that your decision may have been made in error, the Constitution is alive to that. And we are urging the court to allow the parties in exercising that right to preserve the substance of the appeal. Secondly, my Lord, as Mr. Wanyama has said, you have a scenario where we have two courts of concurrent jurisdiction differing on a specific interpretation of the Constitution. Not just two courts, because we have a dissent even in this bench. And that points to the necessity to interrogate that legal interpretation. And in those circumstances, because my lords and my lady, you realize that this dispute is not in persona. It sets certain principles that will be applicable to public bodies. What do public bodies do when you have when you have courts of concurrent jurisdiction differing on interpretation? And I think that is a very important and substantial question that we believe should weigh in the court's mind in whether to exercise its jurisdiction to allow the parties who wish to appeal not to have an academic appeal. I think that is all.
After that, I had Mr. Nura and then Ms. Manani. In case you have a reply to make.
I appreciate that the court is tired.
The court is? What did you say?
The court is tired. It has been
No,
judgment.
no, we are not tired. If we were tired, we would have...
So I would want to make a long...
So I do not think that's a good comment, Mr. Nura. You're starting on the wrong foot.
I apologize, my lord. So,
if you're tired, you say you're tired. If your clients are tired, you say they're tired.
I apologize for that, my lord. My lord, in response, I would just make a single point. And first of all, to deviate from the argument of the 23 versus the 27, my prayer is for a stay for the 50 CS's positions. That this court issues a stay of 90 days for all the 50 CS positions. And in response to the argument by learned counsel and Mr. Ochiel Dudley, that if this court issues a stay on its judgment, what would persist is the dissenting judgment. That is not the correct position, my lord. Inasmuch as there was a dissenting judgment, both judgments fed into the same orders. So this court issued a single set of orders, and that is what we intend to stay. So the orders of the court are singular, they are one, regardless of the fact that there is a dissenting decision by one of the judges.
Yes.
So with that, my lord, that is all. Apologies for my comment.
It's okay. It's okay, Mr. Nura. Ms. Manani, anything to say?
My lord, I have nothing useful to add.
All right. Then that takes, that's it then. We are whispering to each other because the media equipment is here and it's recording us. you very much. This is sought is for purposes of an appeal.
The Court of Appeal was dismissed. The net effect of that is that the second to 51st interested parties, those sworn into office, never took up their duties as CASs because of the said orders. In the circumstances, the orders and declarations made today are incapable of being remedied by a stay because there is truly nothing to stay. In fact, a grant of a stay would amount to setting the CA.
For all of those reasons, we are not satisfied that there are sufficient grounds to grant a stay. The same is hereby dismissed. The respondents and interested parties, and any other party for that matter, may be supplied with copies of the proceedings and judgment. Yes, Mr. Deuri, you are on your feet.
Yes, my Lord, I just wanted to take this opportunity, my Lord, with humility and on behalf of the profession, to thank the court for the decision. Lord, what is not lost to us is the impact of this decision. And we believe that the Kenyans will be able to raise their eyes into the hills. And after a prayer of confidence in the Constitution, but under the Constitution of faith, the judicial system protects the sovereignty of the Constitution. Lord, it is our view that the order of reliance proceedings will be the Constitution of Kenya, and we thank the court for the industry and the diligence that it has exhibited in making this decision. Thank you. Thank you all
for your industry and those submissions. You'll find them in the judgment that we've already signed. Thank you. There being no other matter, the court is now adjourned.
Kora mgojo kaka isewinjo kowuok e doho mamalo en ni welo mar jolup jotend migepe owito ko gi doho mamalo bang' riwruok mar okinde kata Law Society of Kenya nochwalo kese doho mamalo mar pingo kata kwedo welo mar jolup jotend migepe manotim gi jatend piny Kenya William Ruto tarik 23 dwe mar adek higa ni ka doho mamalo kamoting'o joyal bura wacho ni welo mag jolup jotend migepe ne ok otim e yorno makare kendo ok noluwo katiba ka giwacho ni ng'eto ma gigolo kawuono ni en mar nyiso ni jolup jotend migepe manoyier mano ne gin 50 ok bro dhi nyime kaka nochan gi jatend piny William Ruto. Do no bendo wacho ni kata odoko ni jolup jotend migepe 21 notim e yorno kaka nidwaro kai kao pach jopiny kata kamano welo mag jolup jotend migepe 29 nokotim e yorno makare kata kamano bende giwacho ni koro gigo duto manotim kata welo duto manotim mar jolup jotend migepe koro othich oko ka bende nyalo paro ni od bura mamalo ne ok opuodho jolup jotend migepe ka bende doho ne ok otayo kata kinde mane gidhi chamo mane doho ne onge ka koro duto nyakora mogo jwang' gino ma wayudo gi sani en ni welo mar jolup jotend migepe 50 koro thich oko gi doho mamalo bende yangore ni chik ne ok olu makare mar lalruok gi duol mandiko jotich piny owacho kata Public Service Commission joyal buchego ma ogolo ng'eto ma midhiambo makawuono oting'o Kanyi Kimondo, Edwin Ongudi kaachiel kod Alim Visram ma ogolo ng'eto odiochieng' makawuono. Koro gi welo mar jolup jotend migepe nyakora mogo jwang' gi sani othich oko ka bende kaka nawacho ni motelo ni welo margi notim tarik 23 dwe mar adek higani ka ma welo manotim kod jatend piny Kenya William Ruto ka bang'e to riwruok mar okinde kata Law Society of Kenya kaachiel kod Katiba Institute nochwalo kese do mar kwedo welo margi ka odiochieng' makawuono koro oyangore kendo en ayanga ni welo margi othich oko. Nyakora mogo jwang' kochopo saa achiel kod saa adek wabokelo ni matut ko tunre gi weche ma owuok e do malo kaachiel kod weche wabro yudo kowuok e kor gwengewa kochopo saa achiel kod saa adek.